The matter before the court this morning is the case entitled State of Vermont versus Sean Bulson, case number 24AP041. Representing the appellant, State of Vermont, is attorney Jared Bianchi. Appellee Sean Bulson has not participated in this appeal.
Thank you very much. Good morning, counsel. We'll hear from you, obviously, first and only. So please proceed. Introduce yourself, identify your client, and then proceed.
And thank you, Mr. Chief Justice, and may it please the court. My name is Jared Bianchi. I'm a deputy state's attorney in Bennington County, and I'm here representing the state as appellant today.
Thanks very much.
Thank you, Your Honor. The issue before the court is not whether this particular defendant should be held without bail. It's a more basic question, whether the crime of being an accessory, even if the accessory is after the fact, can be discussed within the context of 13 VSA 7553A for hold without bail. We submit,
So,
Your
Mr.
Honor.
Bianchi, if you're looking at the statute, the information, the affidavit that was filed in this case, he was charged with one count of violating 13 VSA section number 5, which talks about accessory after the fact, has a specific maximum penalty, specific fine, and specific requirements on relationships that would occur for somebody who was, say, harboring a felon or a fleeing felon, I guess would be I think that's sort of how the statute reads. So where in that statute is there any element regarding an element of violence?
Your Honor, you have to look to the statutory language referring to the commission of a felony. And this court has been clear that commission of a felony, there needs to be proof of an underlying act. And just as with 13 VSA 9 for attempts or the other sections having to do with accessories, those statutes themselves do not contain each of the elements that must be proven. Those statutes take from them the crime which is being accessorized or attempted. So much of the same.
Yes, oh, go ahead, finish. I'm sorry.
Just much in the same way that a person who attempts a crime can attempt any crime. An accessory can be an accessory to any crime. The court has to look to what that underlying crime is. Here, it has to be a felony. Here, in this case, it's a felony, an element of which includes an act of violence against another person. And so in any situation in which this court looks at any accessory act, it needs to also be looking to those underlying elements of the felony to which the person is attempting or accessorizing.
Okay, so Mr. Bean, go ahead, Justice Carroll. I'm sorry, I forgot you tried to ask a question.
Thank you. Mr. Bianchi, consider these facts. The defendant is on trial for accessory as charged, and the state proves that there was an underlying felony by admitting a certified record from the court that the defendant who committed the murder actually committed a felony. And therefore, don't you agree that the state wouldn't need to get into all the elements? And if so, then this defendant could not be held without bail.
Well, I think that's really two separate questions. First, Your Honor, there's no, the underlying, this court has actually held that there is, that it need not be proven that there was another conviction. So that is not a prerequisite to moving forward here. But even under your hypothetical, Your Honor, it's not clear that just that record would satisfy all of the elements as set forth in the model jury instructions.
But does there need to be elements if all the state has to prove is he was an accessory to a felony? It doesn't have to prove which felony.
We do, Your Honor, because we have to prove the act, Your Honor. That's this court's prior holding, and I believe Williams. It's also set forth in the model jury instructions that we must prove the underlying felonious act in order to hold a person liable for being an accessory to it. So there is no end around to that requirement where we can just submit proof that another person did a thing that constitutes a felony. But even if we did do that, Your Honor, that would still be a record that in this particular case, for instance, a murder or some other particular crime occurred. And there, then, you would still have an element of which involves an act of violence against another person.
So let me try a hypothetical on you, Mr. Bianchi, and see what your response is. I'm sitting at home in my living room, and one night, and there's a bang on the door, and I open it, and it's my buddy. He's covered in blood, comes in and says, I just beat my neighbor with a hammer. Will you wash my clothes for me? I help my buddy out, wash his clothes, give them back to him, and he goes on his way. Are you telling me that if the state charges me with being an accessory after the fact, that I can be held without bail for washing this guy's clothes?
Your Honor, what we're saying is that the court should be able to engage in both steps of that analysis. And in your hypothetical, you'd be talking about the context of the facts in the case that would be proven. This court has held in Filippo and I believe in another case that the court really looks to the elements as to whether this is applicable. You may have a strong argument that conditions of release under the second prong of 7553A are appropriate and could keep the community safe. But
my question was, am I eligible to be held without bail?
Your Honor, if you were charged as an accessory after the fact to the crime of beating somebody up with a hammer, that yes, you would be eligible for that discussion with the trial court.
Mr. Bianchi, can you hear me?
I can, Your Honor.
Okay, so when I look at the statute, at accessory after the fact, the active verb, or verbs I should say, are harbors, conceals, maintains, or assists such offender. So how does that fit into the argument that you're making?
Yes, Your Honor. I think that that's consistent with the broad sweep of this court's treatment of both attempts, but also other forms of accessory, and it is consistent with the sort of the broad policy implications of what the courts are looking at in terms of pretrial release, in the sense that helping a person remain in the community after doing a violent act has the same deleterious effect on community safety and other considerations that this court has as helping somebody in the first instance. And Your Honor, we would point to 7553A's language, which is an element of which involves. So returning to looking at that underlying crime, what is the crime that you have been an accessory to? Those other features that Your Honor referred to, we've sort of been calling them the verbs, right? The harbor, conceal, those activities, that may not itself be an act of violence, but when the underlying crime is an act of violence, this crime, accessory after the fact, involves an element which involves an act of violence against another person. But the conduct that you're speaking to, Your Honor, that underlying conduct, that's really a consideration for that second prong of the 7553A analysis. Nothing about the statute takes it outside of the purview of the courts from being able to have that conversation, have that hearing, and take all of that contextual information in. But it's no different than when this court said that an unlawful mischief case did not involve an act of violence because that's not an element. Here we have sort of rather violence was not an element, even if the context of the case included some concerns around violence. This court said you're not looking at the context, you're looking at whether there's any element. And here there would be an element based on the underlying felony. So, Your Honor,
Mr. Bianchi, do you think that this is to go along with your view of looking at the individual felony itself to make a determination as to the element of violence, the type of felony that's been charged. That would be a situation that would be better off having the legislature clarify that.
Your Honor, we would submit that there's nothing to clarify. The legislature mirrors this, really very closely the constitutional language that requires that there be an element of which involves an act of violence against another person. That's no different than asking the court to engage in that same analysis with respect to an attempt, with respect to an accessory in another context. You have to really look to the elements which become part of that underlying, or that become part of the charge of being an accessory.
Mr. Bianchi, did I in the transcript I read some comments by Judge McDonald-Katie, and she pointed out there's a couple statutes, I'm trying to remember the context, that specifically say in them that this can be considered a crime of violence for the purposes of 7553. And so if the legislature knows how to say that, shouldn't we let them do that with respect to accessory crimes?
Well, Your Honor, these statutes don't work in the same way that the statutes Judge McDonald-Katie was referring to. The statutes that we were discussing had to do with, for instance, lewd and lascivious conduct with a child, other crimes where the legislature, after I believe some litigation and judicial decisions, clarified that the legislature defined these terms and these elements as involving a crime of violence. When you're looking at the accessory statutes, those are statutes that work in coordination with other statutes. So, for instance, the crime of aggravated assault in and of itself, I don't believe that there's a great deal of dispute that's eligible for a hold under 7553A. Likewise, an accessory or a person who attempts that crime can be charged, but you have to combine those two statutes. And the legislature doesn't need to specially define the crime of aggravated assault as involving an act of violence. It's apparent on its face that it is. And where here the crime that the person is an accessory to is murder, there is no special definition necessary because these are statutes that are meant to sit on top of a whole host of other crimes. So in those instances where the legislature has made special definitions, they are self-contained statutes which include all of the necessary elements, whereas these sort of these general provisions in Title 13 are really supposed to be broadly applicable, and they sit on top of the more specific crimes that they apply to.
But Mr. Bianchi, would you agree that the crime of attempt, which has a specific way you can charge somebody who's actually doing the crime by attempting to do the crime, is significantly different than the case involving an accessory after the fact?
Well, I think that I would agree that they are different in the sense that in one case, a person is treated in all respects like a person who has completed the act, but really that comes down to the distinction in sentencing options, Your Honor. Here, the crime of accessory after the fact does carry a lower penalty, but in terms of whether either of those crimes involve an act of violence against another person, a specific element of an act of violence against another person, that really depends on the underlying crime, not on the potential punishment. So, I'm sorry, Your Honor, it looked like you were about to say something. I apologize.
No, sorry. I was just processing the thought, so.
Yeah, so they are the same in the sense that that with respect to this particular analysis, they are not one of those self-contained statutes. You do have to look to the underlying statute, and not just the generalized conduct that's being alleged, but the particular elements. And here, Your Honors, because the underlying felony that needs to be demonstrated is murder, there is an element, a necessary element, which we believe very clearly involves an act of violence against another person. Certainly that additional context with regard to the scope or the type of the assistance and how that may weigh on the court's consideration, maybe a conversation for that 7553A hearing. I think the question is, should we have the opportunity to actually set forth the evidence and make those arguments, which we had not had the opportunity to do thus far. And we would submit, Your Honors, that it's apparent under the legislative intent of each of these statutes, 7553A, when viewed in the context of an accessory charge, that we should be able to at least have that hearing. Thank you, Your Honors.
Okay. Thank you very